Hi, I'm Michael Hackard, founder of Hackard Law. Today we're diving into one of the most critical and misunderstood elements of trust litigation, capacity evaluations. These evaluations can be a powerful tool in cases where a trust or amendment is being challenged, but they're not a silver bullet. To make an impact in court, a capacity evaluation needs to be properly timed, expertly prepared, and fully supported by other evidence. Let's talk about what works and what doesn't. What is testamentary capacity? Testamentary capacity is the legal standard used to determine whether someone had the mental ability to create or modify a trust or will. In most cases, the bar is fairly low. The person must understand what property they own, who their natural heirs are, and what it means to change or create a trust. That's it. So, proving someone lacked capacity, that's no easy task. But with the right strategy, it's possible. When capacity evaluations are most effective, there are four key things we look for when using a capacity evaluation in litigation. One, timing. The closer the evaluation is to the date the trust was changed, the more powerful it is. If a neurologist or forensic psychologist evaluated your loved one just days before or after a trust amendment and found confusion, memory loss, or impaired judgment, that's highly persuasive. Two, qualified experts. Not all experts are equal. Courts give more weight to evaluations from specialists, geriatric psychiatrists, neurologists, and forensic psychologists with experience in legal capacity. These professionals speak both languages, medicine, and law. That makes their testimony more credible, especially under cross-examination. Third, consistency with other evidence. One report isn't enough. We look for a pattern, erratic behavior, unusual financial moves, changes in relationships, and what friends and family observed. If a medical report says your parent was impaired, and at the same time they gave away assets to a new acquaintance or disinherited a child with no explanation, that's a story the court's more likely to believe. Four, legal relevance. A good report ties medical findings directly to the legal standard. It doesn't just say they had memory issues. It shows how those issues made it impossible to understand the trust document, recognize family, or grasp the legal consequences of their decisions, or where capacity evaluations fall short. Even solid evaluations can fall apart if they're not handled correctly. Here's where they go wrong. One, poor timing. If the evaluation was done months or even years before or after the trust change, it may not hold up in court. Unless it's part of a clear ongoing decline, it's too easy to explain away. Two, hearsay-based reports. A report based solely on what other people said without the evaluator ever meeting your loved one is weak. Courts want first-hand observation, not second-hand stories. Three, ignoring the legal standard. If a report says someone had mild cognitive impairment but doesn't explain how that affected their legal decisions, it won't help. Judges need to know, could this person understand what they were signing? That's the question that matters. Fourth, conflicting real-world evidence. If the truster was writing emails, managing finances, meeting with attorneys, and clearly expressing their wishes, it's hard to argue they lack capacity. Even the best medical report can be undercut by real-life actions that show otherwise. Using capacity evaluations strategically at Hackard Law, we don't rely on any one piece of evidence. We build a story. That means pairing medical evaluations with witness testimony, financial records, and real-world behaviors. We might show how a client's mother was diagnosed with dementia, how a new friend suddenly became the main beneficiary, and how this all happened just weeks after her neurologist documented confusion and forgetfulness. That's not just a claim, it's a case. Capacity evaluations are a key part of trust litigation, but they only work when they're part of a larger, well-supported strategy. If you believe a loved one was taken advantage of during a time of mental decline, don't wait. A timely, thorough capacity evaluation might be the first step toward protecting their legacy and your rights. I'm Michael Hackard. If you need help contesting a trust based on capacity, we're here to guide you. Thank you for watching.